You said, "I'm going to beat your ass," didn't you?
Yes.
That was a threat, wasn't it?
Yes.
But you've never been in a fight.
Never.
And then you said, "KO, bang, bang," right?
Correct.
What's KO mean?
Knockout.
You were threatening to ball up your fist and beat the heck out of him.
Objection.
I'll allow it. Is that what you were threatening to do?
Yes.
Some tense moments in court today as Colin Albert was back on the stand for cross-examination. Good evening and welcome back to Canton Confidential, the Karen Reed murder trial. I'm J.C. Monahan.
I'm Glenn Jones. Tonight we have new evidence that was presented to the jury today and more of that intense testimony. Here to break down the details for us is our Kirsten Glaven, live in Denham. Kirsten.
Well, Karen Reed's defense really turned up the heat in a way we haven't seen yet. Colin Albert was at the center of it all, and he maintained that he never saw John O'Keefe the night he died.
Commonwealth versus Karen Reed.
Colin Albert, nephew of Fairview Road homeowners Brian and Nicole Albert, back on the stand and during a fiery cross-examination by Karen Reed's defense team.
I do.
The 20-year-old grilled about his family's relationship with the lead state police investigator on the case, Trooper Michael Proctor.
Your family was close enough to the Proctor family such that you were a ring bearer in Courtney Proctor's wedding, right?
Correct.
And who's Courtney Proctor's brother?
Michael Proctor.
And is Michael Proctor in the photograph that you're looking at?
Yes.
The jury later shown this picture of Albert, taken about a month after O'Keefe's death. Albert claiming he slipped on ice, resulting in the injured knuckles.
So I had tried to brace myself with my right hand, and I ended up sliding a little bit down the driveway.
You injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
Seriously?
Reed's defense playing two videos of Albert for the courtroom.
You indicated you're a bro, right?
Correct.
Was that a threat?
Yes.
And then you said, "KO, bang, bang," right?
Correct.
What's KO mean?
Knockout.
Albert explaining the videos were taken years prior to the incident and that it was sent to members of a club hockey team.
It was the girls in our friend group, a couple of the girls in our friend group, like hung out with them a few times. So like all my guy friends got a little salty about it. So that's why we kind of sent videos back and forth.
The Commonwealth bringing it back to the case at hand.
At any point in time, did you see John O'Keefe at that house, come into that house, around that house, at any point in time that you were there?
Never.
Next on the stand, Matthew McCabe recalling seeing Reed's SUV parked in the Alberts' driveway the night O'Keefe died.
Just looking out, being like, what the hell are they doing?
McCabe testifying that he saw abnormal tire tracks in the snow.
It's just a weird, like a wave. It was a weird wave in the road. You could see the tire marks.
He added that after looking out 3 times, the dark SUV had moved down the road and that neither Reed nor O'Keefe made it inside.
I must have looked out one more time because there was no vehicle there anymore.
Now, Matthew McCabe will be back on the stand first thing tomorrow morning. We're also expecting to hear from his wife, Jen McCabe, who was with Karen Reed the morning John O'Keefe's body was first discovered.
Kirsten, you've been there in Dedham for us, and after the trial, you've been able to talk with the defense team, even to Karen Reed outside of court most days. But the question is, are you hearing anything from the prosecution side when they walk out of court?
We have not, and there is a reason for that. They have never exited, as far as we've seen, from the front of the courthouse here where all the media has been staged. Only the defense team has walked out the front door. They've been going out the side door, the back doors, things of that nature. So it is by design. They are aware that all the media outlets are here covering this high-profile case, and they do have representatives, attorneys and things of that nature representing family members, witnesses, things like that. So they are aware that we are here. They just have not made themselves available for any type of comment yet.
Kirsten, thank you. That's obviously why we're hearing more from the defense than we are from the prosecution, because they're adding to it. after court. Kirsten, keep reporting for us. Thank you so much. Joining us now in studio is criminal defense attorney Peter Ellikin. Peter, thanks for being with us.
Terrific to be here.
We started the day with a sidebar. The defense basically trying to stricken from the record, Allie McCabe's testimony from yesterday, because she got emotional right at the end. She started crying. She started talking about the harassment that her family has endured over the last year and a half. The defense argued that that should never have been admitted. The judge disagreed. Can you just tell me what they were trying to pull back and retract?
Well, yeah, clearly, first of all, trying to pull back and retract after the jury has already heard it is almost a ridiculous exercise. But technically, you just want to do that to try to keep the record clean, even though the jury can't unhear what they heard. But clearly, they want the jury to just focus on, innocence or guilt here. And the idea that a witness somehow feels threatened really has nothing to do with that, but might try to prejudice, against the defense, against the defendant, the person charged here. And that's why they clearly wanted to get that out. It's a sideshow. It has nothing to do with the point of the trial, really. So I see why they did what they tried to do.
But the judge in the end said you opened the door to it by asking her about why she didn't show texts and why she showed them when she did. Her answer was, because I had to show them to prove we were getting harassed because people thought Colin was at the house that night and he wasn't. So that was a loss on the defense side.
Yeah. Well, let's talk for a minute about those videos we showed of Colin Albert that the jury did get to see. We don't know precisely when they were recorded. It looks like he was a teenager at that time. But Colin Albert did testify on the stand that those videos are not related in any way to John O'Keefe. So why does the defense want them to be presented in front of the jury?
The defense wanted to show that he's a propensity for violence, that he's the kind of person who would attack somebody physically, who would beat them up. And this is a perfect example of reasonable doubt. Because first, Colin says, I've never been in a fight in my life. And then they're saying, but here's a video. You threatened somebody, you knocked KO, knocked them out, you clenched fist. And what were you trying to do? Yeah, we're threatening to beat them up, but I never would do that. And then again, they show another video, the same kind of thing. And then it turns out when they also show some photos of bruises on his knuckles, and they say, how do you get that? And part of his answer was, well, I'm doing it on the heavy bag. The heavy bag is for boxers to train to fight. So when the jury hears that, maybe Colin is telling the truth. Maybe he never has been in a fight in his life and is just threatening. But meanwhile, the jury's hearing this and say, well, I don't know. And if they're not sure, it's like we have an old baseball adage, tie goes to the runner. If the jury hears both sides as well, maybe he has fought, maybe he hasn't, then that's reasonable doubt.
This is really important for the third-party culprit defense, right? Because I guess they just need to convince the jury that it's possible somebody else could have did this, but they don't need to prove somebody else did this.
Right, and they may never have absolute proof, but also I'm waiting to see what the defense evidence is going to be when they introduce it, and we're going to have to wait a few weeks. So the best they can do, the defense counsel can't introduce evidence. All they can do is ask questions and kind of cut away, but they're kind of building on a theme, getting it in the jury's head, and then when the defense comes down, they could really, they say, now we're going to show what we were leading up to.
Got it. Peter Ellikin, stay right there. He's going to be with us a little bit later, right after the break, because our conversation continues.
Sue O'Connell, our courtroom insider, will join us right here at the table, how she describes the jury's reaction to today's tense moments. Welcome back to Canton Confidential. I'm here with Sue O'Connell, our courtroom insider and commentator. And Sue, your role is so important because we all have our conclusions watching the testimony online or on television, but you're in the room. You can see some of the reactions and interactions that we cannot see at home. So after a day of testimony with Colin Albert, I must ask you, how did you read the room based on how dramatic that testimony was?
Well, I'll tell you, first of all, I also haven't done a deep dive on this. I hadn't seen those videos before. I'm trying to be in the courtroom like the jurors are in the courtroom. And It was a sleepy morning. The jurors were getting a little bored before Colin got up on the stand for the rebuttal. There was a sidebar. They had to leave the room. And when they left the room, there was a voir dire with the defense and prosecution about whether these videos could be introduced. He was questioned. So we went through this once, and then the jurors come back in, and they're all like, oh, here we go again. And then, bam, these videos are played. And, you know, I understand what it's like to be a teenager, and I certainly know a lot of teenagers who put crazy, wacky stuff up. He did this when he was 15, 16, or 17. But it was really striking because it was the first time we had not just a picture of the house, not just a laser pointer of where the cars were, but these loud, explosive, content-filled short videos, and it really got their attention. And I think, you know, granted, it happened when he was a teenager. He's not a teenager anymore, but I did see them looking at him and wondering if this was the same young man in the videos that they see sitting here with a nice collared shirt on, you know, not being a great answerer, but being polite at least.
Sometimes when you watch an aggressive cross-examination from the defense, you can start to feel sorry for the witness on the stand who's really facing a barrage of questions. Based on your read of the jury, were they sort of going along the ride with Alan Jackson or getting frustrated with his aggressive questions?
So what happened before the aggressive questions was a lot of I don't knows and I don't remembers from Colin, and a lot of hammering from Alan Jackson to try and get some basic answers. And I saw a couple of jurors, and I don't know if the frustration was with Alan Jackson or with Colin, but they were just like kind of shaking their heads like, come on, just answer the question, answer the question. And I don't know if they felt any sympathy for Colin, obviously, about he was struggling to answer or if he was being evasive, what their take on it was. But when Jackson got up and swore, said the F word, said the P word, said a bunch of other words, and basically physically reenacted what the threat of the video said, and Colin admitted it was a threat, the jurors really were paying attention. I didn't feel so much that they felt badly for Colin, so I'm not sure where they ended up, but they definitely were riveted by the animation and the amplification and the personification that Alan Jackson brought to animating these videos that we had watched.
All right, there was one other key moment earlier on in the testimony where Alan Jackson seemed to establish that Colin Albert knew Michael Proctor, the investigator in this case, for a long time. Explain the significance of that moment in the context of everything else you've heard.
Right, so he's known him his whole life, just about. He said he was a ring bearer in his sister and John Proctor's sister Courtney's wedding. There are photos of that. Colin testified he's seen him 3 or 4 times. He's been to his parents' house. But again, this makes the connection even deeper, right? That someone who is a ring bearer at your sister's wedding is who you are interviewing in this murder investigation. So, you know, you don't need to be a conspiracy theorist. You can be maybe you should have excused yourself from investigating this because of the close family ties, or, you know, thinking that some smart lawyer is going to find this picture or get this picture sent to them and get it introduced, and that's going to impeach your ability to be a fair and objective investigator. So, you know, it is, again, not a moment that I understood. I didn't know that he had been a ring bearer, but you could see the looks on faces jurors as they're like, oh, another connection to this Proctor, and here he is holding a nice little pillow with a ring on it. We didn't see the photo, but I imagine that's what it looked like.
Yeah. All right. Well, thank you very much for being in the courtroom every day. Your perspective to see what the camera can't is so important. Sue O'Connell. Stay with us. When Canton Confidential returns, we'll be talking about some of what we are seeing in the courtroom, from the demeanor of Karen Reed to the clothing of witnesses. Is it all intentional? That's when we come back. Back now on Canton Confidential. There's a lot at stake in this high-profile murder case. The dramatic moments we saw in court today exemplify that.
And for those of us who are not part of the legal process, so many of us just don't know how much preparation really goes into it, down to those very small details. So joining us now is Andrew Capelshaw, a licensed attorney and trial consultant with Act of Communication. Andrew, a trial consultant, that is a unique job. So could you explain a little bit about what you do?
Sure. There are all kinds of trial consultants. There are trial consultants that specialize in jury work. There are trial consultants that specialize in graphics. Our company was founded 47 years ago by two graduates of the American Conservatory Theater who had an experience with a jury trial that they described as the worst piece of live theater they had ever seen. They didn't like any of the characters, and the whole thing was based on audience participation, but the audience didn't know what they were supposed to be doing. And so the question was asked, why don't lawyers work more like actors in terms of learning how to use their voice, learning how to use their body? That eventually led to, how do you tell a story? And now the majority of the work that we do is in witness preparation, getting witnesses ready to communicate openly and honestly and connect with the jury.
Okay, let's apply that background to this case. There has been a lot of talk about how much the witnesses in the Karen Read murder trial have been prepared or not prepared. Let's take a look at this moment from earlier.
Were you given any instructions by either Sergeant Tully or Mr. Lally about your preparation for your testimony? How they wanted you to answer questions? The tone and tenor of your testimony?
No.
How they wanted you to dress, for instance?
No.
So, Andrew, we heard him say there that he was not told what to wear. Is that something that witnesses are typically told to do? And what's the best way to approach preparing a witness?
Sure. Those are two very different questions. Let me start with, is this common? Yes. We're always going to talk to a witness about how they're going to dress, how they're going to carry themselves during the trial. But that's not necessarily the case, because you have to remember that these witnesses are not the clients of the prosecutor. So any conversation that happens between the prosecutor and these witnesses is something that the other side can ask about. So the prosecutor is going to have to tread very lightly, as opposed to when you're talking about, say, the defense with their own client. That's not going to be something that you get to ask about, because that's attorney-client privilege information. So when you're doing my job, one of the first questions you have to ask when you're talking to a witness is the conversation I'm having with this person to prepare them going to be something that they can be asked about on the stand, which is what happened here.
So you're saying, so in other words, he was prepped perhaps, but not by the prosecution? He would,
because he's testifying no, I'm going to presume he's not going to perjure himself there. I don't think he probably was prepped, it sounds like.
Okay.
Now, a lot of the times, go ahead.
If we talk about Karen Read specifically throughout this, so she's the defendant. We've talked, where people have noticed and have said how she's sitting with 3 attorneys, and if you didn't know who Karen Read was, you wouldn't necessarily be able to pick her out. She's dressing in this similar manner, dark colors, conservative sort of suits. Is that something and that she would be coached on, or the way she shows emotion, or when she smiles? You talked about that, like the theater of it.
That is absolutely something that a lawyer should be doing. If not with a consultant, they should be doing it on their own. What confounds me about this case is the way that she's dressing and the way that she's carrying herself is really the exact opposite of how I would advise a client to dress and carry themselves. You say she couldn't tell looking if she, which one of those is the client, which one is the attorney. There are statistics. There's been research going back 50 years on trustworthiness and credibility by profession. Lawyers are third from last and have been for half a century. So why you would want to dress your client like the third least trustworthy and credible profession on the planet is something that I have really no clue in this particular case.
So what would be more effective then, if not dressing like a professional courtroom attire?
Typically what we would want to do in a case like this is go with warmth, earth tones, or maybe a little bit of a pastel. You want softer fabrics, you want softer colors. You want to find out who this person is and dress them so that they're authentically themselves, but at the same time, the more approachable version of themselves. We all have different versions of who we are. And the thing that really confuses me about the strategy in this case is I'm hearing witnesses say she was great with kids, she was lovey-dovey, she was, this soft, wonderful person. And yet the person I see at counsel table is not that person. And so my job would be to come in, connect with her, find that inner, soft, warm, wonderful person, and try and get that person at counsel table and dress that person to be who she really is in the courtroom, rather than turning her into something that looks like a lawyer.
This takes money, though. I mean, to hire somebody like yourself takes money. Prosecutors typically sometimes don't have the same amount. We're running out of time, but thank you so much. We're going to have you back on because you have such a unique perspective. Andrew Capelshaw, thank you.
Thanks for having me.
All right, and when we return, we'll have more with Peter Ellikin. Questions. This is from LB. She asked, quote, why is having a dead body on the property or front lawn not considered probable cause to search the home?
Peter Ellikin is back with us. What do you say?
I say there's probable cause to the 10th power. I mean, somebody's expected at a party at a house. The next morning they see his body in front of the house on a lawn. That's enough to, was there anything going on in the house? How about the people inside? How about take them aside? And if there was any question in the police officer's mind, he could have gone and gotten a search warrant and been back in 45 minutes or something. So that is absolutely probable cause.
Thank you, Peter.
And confidential.
See you tomorrow.